for more insights into the Senate's decision to archive the impeachment complaint against Vice President Sara Duterte, we have Paolo Tamase, Assistant Professor at UP College of Law, joining us today via Zoom. Magandang umaga po sa inyo.
Magandang umaga din po. Good morning, Angelo and Angela.
Opo, of course, we would want to know yung naging reaction po ninyo dito sa naging botohan ng Senado kahapon sa pag-archive ng impeachment case against VP Sara.
I suppose, and just to clarify, that the UP College of Law doesn't have an official position on this.
Okay.
Yes,
But talking to colleagues in the college, I think you can describe it as not surprised, but still dismayed. Right? We're not surprised because since February, you've seen so many new novel ways of trying to delay the trial of the vice president, and even, we haven't really even come close at all to the evidence against and for her. But at the same time, despite that lack of surprise, we are dismayed because I think it's a loss of an important accountability mechanism in the Constitution.
Well, a while ago, Prof, we were speaking to one of the framers of the Constitution, si Attorney Christian Monsod, and he says he really believes that there was an overreach by the Supreme Court over the function of the Senate and the House with regards to the sole power to try somebody and hold accountable. Now, do you think, if so, what happened sets a dangerous precedent moving forward and making the filing an impeachment case against an official more difficult?
I think it is dangerous precedent, with all due respect to the court, and fully aware that there's a motion for reconsideration still pending with them. I think if you look at impeachment, and one anecdotal thing I always say is that when the first impeachment I had was a 10-year-old watching the Estrada impeachment, and that was not difficult for me to understand at all at that age. It means that the process was designed to be extremely accessible to the public, including those who don't have a legal background. And so, more than the risk of making it more difficult to initiate impeachments, I think the legalization or over-judicialization of the process will tend to alienate people from what is an accessible way of finding out the truth about the moral fitness of a high public officer to serve in these very important positions.
Yes.
And I think that's the real loss here.
Well, on the July 25 SC ruling, naka-point out doon na naging parang proactive, or tama ba, not retroactive yung naging rules nila pagdating doon sa pag-identify ng official impeachment complaint. Now, a lot of people are asking right now, and we would want your opinion on this, what happens now doon sa mga previous impeachment cases?
Well, I think the general rule is any ruling of the Supreme Court, or especially a finding of nullity, retroacts. But if there is an inequity that will result, or if there is a reliance of parties on the rules that were laid out by the Supreme Court before, then the court prudently applies the ruling prospectively only for the future. You don't see that language in the decision now. And I think there are valid concerns raised about past impeachments that were already conducted.
Exactly.
There is a possibility that they will be reopened. But insofar as, the only two successful impeachments we've had, President Estrada and Chief Justice Corona. President Estrada is no longer in office and his term would have been expired anyway. Chief Justice Corona is already deceased, and therefore at least the immediate effects of whether they will be back in office might not be there. But it is a concern, right? It rewrites the rules somehow on impeachment.
Right.
Yes, and sabi nga ni Attorney Monsod, when they wrote down the Constitution, they had the people in mind with the power to give us, hold people accountable. Now, sabi niya, even if this impeachment process was not successful, there is another recourse now by going through the Ombudsman to file cases which can hold all the officials, even Senate, Supreme Court, and even the Vice President, accountable. And from there, it's not only now perpetual disqualification, but the criminal cases also. So do you think this is a possible route if after the MR is, if ever it is denied?
Because he upheld this ruling.
Right. So I think it's a possible route, but I have two important caveats briefly. The first is there is language in the opinion issued by the court, in the decision issued by the court, which suggests that high public officials are immune from suit before they are impeached. And I don't think the larger body of jurisprudence and Philippine law backs that up. So you do have that dangerous language in the decision, which I think my colleagues and I hope the court will correct. But the second goes back to the real reason why impeachment is, unique in our system. It's because of its accessibility.
Yes.
Now, once you have these cases with the ombudsman, these are closed proceedings. We have no idea how the decisions of the ombudsman will be done. We do not get to see how the case will be tried. And therefore, on the more important question of whether you can trust this person outside of the legal issue, but more of on the political side, whether voters can still trust this person, we don't get to see that. We don't get to see that dynamic. So impeachment is not substitutable by any of these, even though there are, and Commissioner Masod is correct, multiple ways to hold people accountable.
I'd like to touch, Prof. You said that the language of an official being the president being immune from suit. Parang the explanation there was because if you put or subject the president to a suit or as a demanda, it takes away his time from functioning as a president. Pero there were also some luminaries saying that the vice president is a totally different position with no direct function except that to replace the president or if he's appointed to an office. So do you think even the vice president, given na wala naman direct function, is immune from an actual suit, a criminal suit?
Absolutely not. No, I don't think she is immune. We have a theoretical basis and a practical basis for immunity from suit. Angelo, you're right. You talked about the practical basis of the president being just bogged down by all of these cases. But in our constitutional system, we only have one person in the executive department, and that's the president.
Yes.
Everyone else just helps him out.
That's right.
But all of the other impeachable officials, other than the vice president, belong to collegial bodies, which means that the body will continue to exist. But the vice president constitutionally is a spare tire. So that immunity from suit doctrine also does not apply to, or the rationale behind it also doesn't apply to her, in my view.
Okay. All right. I want to go back to the word archive. Okay. Sa layman's term, alam naman natin when it's archive, pwede naman ma-retrieve. No? But of course, questions raised doon sa naging desisyon ng Senate yesterday on having the impeachment case being archived because yung kanilang condition doon ay kailangang pagbotohan pa kung gusto nilang i-retrieve yung archive nila. Is that, what do you make of that decision?
That's absolutely right. Archive from the matter of law, ibig sabihin nun, nandiyan pa rin siya, hindi siya patay, pwede siya buhayin, right? When the Supreme Court comes up with a decision. And so theoretically, the case is very much alive. It's asleep. Think of it in either deep freeze or deep sleep. But from a practical matter, we go back to the point I made earlier where you always find the Senate in the last 7 months looking for some excuse not to proceed to trial. And one of the key excuses that is now available to it, let's say in the hypothetical scenario where the Supreme Court reverses itself, is you now have the Senate with this question again. Are you going to revive the case from the archive? So boboto na naman yan. And you saw a 19-4-1 vote yesterday. That's not a very encouraging sign.
Right.
So that's why si Senator Soto thought more prudent daw ang tabling, no? Tabling means, Prof, you don't vote anymore. Basta MR granted, hypothetically, automatically, they'll take it up in plenary and have to convene as an impeachment court.
Yeah, that's the result. Tabling means that instead of the motion being voted upon, the motion will be essentially put on the table, left on the table only. So they're not going to act on it. But so I think that was really the more prudent, more constitutional way of going about this. But the Senate clearly had a different take on it.
But you said earlier that the archiving of impeachment, you were not surprised, but of course you were still dismayed. Pero doon sa pagboto ni Senator Lacson, were you also surprised that he abstained given na he was supposedly one of the supporters, of course, in the minority side?
Well, I wouldn't say I'm surprised. Senator Lacson, I think, did give an interview a few days ago, and I may be misrecalling it with that caveat. where he basically said, respect the Supreme Court's decision. But I think one important point to highlight yesterday was the return of the institutionalists to the Senate.
That's right.
There are people who care about the Senate as an institution and its place in government, its high place in our systems of checks and balances.
Right.
You got to see that yesterday, right? You got to see 5 people argue it out, including Senator Lacson. So that's, if you're looking for silver linings in this whole thing, that's one of them. You have people who really care about the Senate as an institution, but you need more than 5 in order to make that, really work.
Well,
what you said,
unfortunately,
silver lining.
in politics, majority rules. But thank you for your time, Prof. And we hope to have you again. Of course, may updates pa yan in a few days, and we hope to see and get your insights. But for now, thank you, Paolo Tamase, Assistant Professor at UP College of Law.